show the way, be the leader. Okay, you've got to show a court how to uphold your case. I mean, this is part of advocacy, isn't it? It's about persuasion. But you've got to, really show them the blueprint, how they can get there. Courts are nervous Nellies. They sort of worry about things. They worry about appellate courts being overturned. They worry about picking up the, what's your paper down here, the Melbourne Sun or something, and finding on page 3 sort of, stupid judge made bad decision. And so they worry about these things, and they worry about their peers or tut-tutting. So you've got to show them how they can do it and get there. And, it's very easy when we're environmental sort of, viewed with environmentalism to sort of do this incantation of principles and say, the precautionary principle says that. Well, maybe it does, maybe it doesn't. But you've got to do more than just give that sort of, particular, sort of like a mantra, sort of recite the mantra. You've got to actually show them how they can use that. And, the ESD principles is a good one. Sometimes we get them coming along, and if you've watched that great Australian film about the castle, and they come along and sort of, go to the High Court and sort of, what is it about the Constitution? Well, I couldn't find any particular principle, but it was the vibe. Okay, well, I can tell you how many times I get in the court, somebody coming along and say, well, it's contrary to principles of sustainable development. Well, what particular aspect? Well, just really it's the vibe of them. Well, that's just I've got to cut the mustard. So you've got to come up with, show how you get there. The next one, choose the suitable vehicle. All right, we've got a great idea. I've taken out of my drawer the idea for the next case, etc. But you've got to make sure that this particular case has got the right facts, you've got the right plaintiff, you're going to get the right remedy. Okay? It's no good trying to package a great idea in a, beat up, broken down car. You've got to find the right vehicle. Now, that means not only can you prove your elements of your cause of action, but you've got to be able to get relief. Right? It's no good, as I say, establishing breach of the law if you can't get some sort of relief. So I'll give you a little example there. This was actually an EDO case, but and the problem was in that case is that it was a very technical legal argument. It didn't ever have any environmental hook to it because we were at a preliminary stage, and they went for a protective cost order, and their client was some of the wealthiest farmers in Australia. Right? It wasn't a great vehicle to run and develop the law about protective costs. So choose carefully what you're going to do. Make sure that you've got the right plaintiff and the right case, and you can get the right remedy. Okay, the next thing. Although of course the courts, judges must apply the law, we've got to remember, as Justice Kirby said, there are leeways of choice in finding, interpreting, and applying the law. Of course, in finding facts as well, but in granting discretionary remedies. So they've got to be persuaded to come your way. Right? It's not black and white, contrary to what some people in the press like to say. There always is some sort of choice that you're going to make. But why go this way as opposed to that way, right? Well, people want to feel good about themselves. I mean, again, judges don't want to wake up in the morning and say, oh, great, let's see if I can destroy the environment. Let's see if I can sort of, wreak havoc upon people. Maybe they do want to go home at night and sort of, talk to family or friends or something and think they've done something good in the world, right? So it's a natural human reaction that they want to do it. Well, make them have that emotive hook that if they do this, they're going to feel better about themselves, okay? And doing it feels like intellectually and morally the right thing to do. So try to think of that. What is your hook? Now, it's obviously easy if you've got a compelling story. You've got strong facts, you've got reasons of justice and fairness that, back up the law, right? That's going to be easier. People will sort of bend over backwards not to do something which they think is fundamentally unfair. Or so you sometimes see, the joke in the show when I was at the City Bar, going in and, people would have sort of a whole trolley load of, cases, all the Commonwealth law reports and New South Wales law reports, etc. And the other barrister would look across and sort of tut-tut and said, weak on the facts, are you? Well, that was the thing, you always tried to come up with some good factual stories, so make sure that you've got it. Okay, the next one. Ensure appropriate remedies. you've got a choice of your cause of action. Obviously, if you're in common law, then it might be damages. You might say, well, but I want an injunction, so I've got to get an equitable remedy. But if you go with some of the statutory, environmental statute ones, you might not be able to get damages. Right? And if you're trying to, for example, get money in order to compensate for the loss of habitat or species or something like that, it may be fundamental that you get some money to compensate so that you can reinvest in equivalent habitat. So you've got to think about what it is. And of course, with the courts, you know, you go to VCAT as opposed to the Supreme Court of Victoria, they've got different powers to give different remedies. You've got to think about that. Also, be realistic about what can be achieved in litigation. You know, litigation is a tool, it's not an end in itself. And so remember what you can do. Judicial review is a very effective cause of action, but we have to remember that what it does is it's like a judicial remand. It sends it back to the executive arm of government to remake the decision according to law. Well, of course, they may come to the same conclusion. They just do this time through the right process. But we've got to recognise that that's always a possibility. But sometimes, when they do go through the process, they do come to a different decision. And the last one is then, on this first one, is avoiding that scattergun approach. Poor arguments deflect attention from the good arguments, but they also do more than that, they taint good arguments. Because what happens is, the court and the judge can't work out which is the good point from the bad. Everything's in there. Once they start thinking, this is just hopeless, this is hopeless, you know, the whole case is hopeless, right? It suddenly sort of gets that. So be discriminating, pick your good points and seize it, right? That's a good advocate, by the way, does exactly the same. The poor advocate is the one that sort of says, there are 52 reasons why this is bad, and they try to work their way through. And of course also it adds to costs, and costs have to be very conscious if you're a public interest litigant. Now that's my first big category. The second one is just start thinking what the defence is going to do. Right? What are they going to raise, and how can we preempt that right up front? Okay. For example, justiciability, it's a big issue in America and all these climate change cases. Not so much here. But if they were going to do that, how could you get around it? You know, some things are more justiciable than others. So you might add a cause of action, or you might choose one which is less vulnerable to that argument. Standing, right? If you're going to have a conservative jurisdiction where they're going to have standing problems, think about who your plaintiff is. What are you going to do to try and make sure that that person's got standing? Then other things like, are they going to make applications for damages or things? What can you do about that? Your cause of action or the defences, you know, anticipate what they're going to do and how you're going to rebut it. What if they're going to run an argument saying, you know, the end of the world is nigh if we can't rape, pillage and generally destroy the world? What is your response going to be? How are you going to sort of balance that? All right, next one. Give me 2 minutes. Okay, so case prep. Really, you've got to have a strong case theory. So if you can't articulate right from the beginning what it is that you're doing in court, then you shouldn't be going to court. How often I will ask in the first opening when they come in and I say, okay, so what's your case? And they ramble on, they can't really work it out. Well, what's your key point? You know, how are you sort of putting it? They haven't really worked it out, okay? You have to have that. You've got to be able to articulate that right from the beginning. Remember that being organised is critical. Most cases, believe it or not, are won before you go into court. It's pretty bad for business for barristers, because barristers like to think that they're won by reason of your great advocacy, but they're actually not. Right? And no matter how good a barrister you are, you've got a crummy case, you never win. Okay? You've got a good case, then your bad barrister skill can lose it. But you really do need to have that prepared beforehand. So go through the facts. I've suggest a little chart there. I'm happy to talk about that with people about sort of ways you can do it. Look at the law, and you've got to develop that. Now, the next thing, facts. Law. The other thing is, remember that as soon as the very first time you file process in court, it's a chance to persuade. And every document you file is a chance to persuade. Now, you may or may not be hitting the ultimate decision maker, but there's increasingly a chance that you will. because with case management and sort of docket system, you may well be getting into the particular person. So the earlier you can persuade them, the better, right? Unintelligible pleadings, affidavits that are poorly drafted, all of that just paints loser, okay? So you want to paint winner, and so you want to set this tone of a winner right from the beginning. All right, from the opening, I just make a quick point. One is, again, remember the emotive hook, all right? Your first 15 seconds or so in court are important, right? This is the first time you're engaging with the judge, and you want to try and make an impression. It's prime real estate. So think about how you're going to open it. What are you going to do? And if you've got some documents, if you get the opportunity to file in advance an outline of opening, you've got in before your opponent to actually start showing them why you've got a winning case. Right? So, and then of course, be ready all the way through. Always be in control. This calm competence control, that's all really important. And you've got to cultivate the ineluctability of victory. If you've seen the really good advocates in court, it's well worth going and sitting in. They never have a shadow of a doubt that they're going to win, and the court has that feeling, like it's absolutely inevitable that this is going to end up in this way. Not in an arrogant or brash way, it's just they have an aura which sort of says it, and they cultivate it from the case, they cultivate it from themselves. You've got to have that. Now, it's because of that, the importance of that, that you get this sledging and tactics. Sydney's probably worse than anything, it's just sort of like the New York of the Australia. It's laissez-faire capitalism at work, the New South Wales bar. But they'll try and sledge, they'll try and do tactics, they'll try and do anything, of course. Why? Because they want to distract you. And so it becomes really important to try and make sure that you don't get deflected by them, stay on message, and go through. Terrible. One is keeping control, which I just lost. And the adaptive management, just like environmental, you've got to try looking at how the case is going and adjust. Right, the last ones were then closing. You've got to see what the court is, keep seeing what it's going to do, and show them the way how they can get to the judgment. Give them their facts as to what the findings, give them the law, make it easy for them with unreported decisions, and hopefully give them a draft judgment so that they can sign on the dotted line. Thank you.